Yes, please.
My Lord, before the proceedings start, may I respectfully thank your Lordship for accommodating us despite your Lordship's very hectic schedule. We deeply appreciate it, my Lord. We're most grateful.
It's fine, Nancy.
Yes, sir. My partner, Bolu Agbaja Kedri, will anchor the proceedings, if my Lord will permit me.
That is fine. There are certain things that I need clarification on anyway.
Yes, sir.
On the 19th of October 2020, Jessica Modoze appeared for the applicant, and there was no representation for the defendant. Right?
Yes, my Lord, that's correct.
The Jessica Modoze announced appearance for the applicant on that day. The application that was pending was the application for stay of proceedings. Is that correct?
Yes, my Lord.
And she appeared for the applicant. That means for the party that filed the application for stay of proceedings.
My Lord, we are bound by the record of the court.
So the records indicate that Moduze informed the court that the judgment data has compiled and transmitted records. We asked the court to strike out the application. Right? And then the court ruled on the application of counsel, this application is hereby struck out. Mr. Veleko?
We are bound by the records of the court. Jessica is a colleague in my law firm, and we are for the judgment creditor. We are not for the judgment debtor. I wasn't at the proceedings and have never seen the record of my note, so I would not be able to ascertain that he appeared.
She announced
appearance
for the applicant here. On the 19th of October 2020. I believe this was in open court. It was the day before the unfortunate incident at the Lekki toll gate. I remember that day. I was the only court
that's correct, my Lord.
In the Lagos division on that day. So it was in open court. It wasn't virtual. So she announced appearance for the applicant then. I just want clarification as to what application she will do on that day, because the judgment debtor is contending here that they had no knowledge and they were not served with the hearing notice for proceedings of that day. So if Ms. Modoze or Mrs. Modoze, as the case may be, appeared for the applicant, which applicant was she appearing for?
So I'm very surprised to hear this. We are for the judgment.
You can apply for the record of proceedings.
We have actually applied. We didn't know that my Lord would accommodate parties within a short while. So we have applied. In fact, we intended to annex it to our counter after we must have reviewed it. My Lord, I'm shocked to hear what is on record. What our update states in our case note is that she appeared for the judgment creditor. The judgment debtor was not in court, and the record having been compiled, the court struck out the application, which in any event, the court did not have jurisdiction to proceed with the said application.
All right.
My Lord, it is obvious that it's obvious from the record, sir, that the judgment debtor was not in court on that day.
Yes.
It's also obvious that counsel who appeared in court on that day was counsel for the judgment creditor.
Yes, but she announced appearance for the applicant.
Applicant. So
were pending on that day.
Yes.
So that was pending was stay of proceedings.
Exactly. And so perhaps maybe she was a junior and was not as conversant with the case file as she ought to be, because I do not think it could have been out of mischief.
Yes.
So maybe that is what must have happened. But whichever way your Lordship looks at it, that gives proportion to the necessity to look at the application which we have filed.
Yes, I just wanted clarification on that, Leonard. Now, and another issue is the registrar informed me that the judgment creditor had filed a counter affidavit and an application to regularize SIN. Have you been served with that?
My Lord, prior to the proceeding, I liaised with a colleague from the Learned Senior Advocate Office that will file processes the counter and the application to regularize it. And we promised to forward it by email, which we did. I'm not too sure whether they have received it. We forwarded it not long.
Let's hear from the Silk.
My Lord.
Yeah, Bolu, can you take it here, please?
All right, thank you, my Lord. My Lord, we just received the advanced copy of that counter.
Hold on, let me have it on record.
After the process. Okay, my Lord. Bolu Agbaje Academy.
Yes, Mr. Yusuf. Mr. Yusuf.
Oh. Yes,
you filed an application. You filed A counter affidavit?
We filed a counter affidavit, the post today, my lord. Yes, my lord.
With an application to regularize?
Yes, my lord.
Have you served the judgment debtor?
My lord, we are only able to send it by email. Of course, having been filed this morning, I would not be able to confirm to the court whether it's duly received by the judgment debtor. We do not have any acknowledgement.
Mr. Akadiri, right?
Yes, my lord.
As the copy.
My lord, we confirmed that the application was sent to our email.
Yes.
During this proceeding, and we are taking steps right now to even print it out in our clerical section. Be that as it may, my lord, and I say this with due deference to my lord and my learned friend on the other side.
Yes.
My lord, we have a very serious issue on our hand. From the further affidavits that we filed, the one that was deposed to on the 2nd day of November, my lord. My lord will see clearly, even from the letter, the correspondence from Wema Bank, that all our client accounts have been put on note as a result of this order, the garnishing order night side. The banks, not only Wema Bank, GT Bank did the same thing, Access Bank did the same thing, and they are not only restricting it to the judgment debt, my lord. They have extended it to the entire balance in those accounts. That even as we speak today, October salaries have not been paid to pilots. These are people that they work in the essential industry in this country. They fly helicopters. So, my lord, it's a very serious matter on our hands.
That is why, Mr. Akadiri,
yes, my lord.
I rose early from proceedings today so I could take this virtually because there are 2 affidavits you deposed to indicating the urgency of this matter, right?
We are very grateful.
Now, however, that does not mean that this application must succeed. You must know that.
Yes, my lord.
Right? Now, however, there's a problem that did not start with this application. When a judgment creditor brings an application for garnishee order NISI, right? The judgment creditor lists out all the banks in Nigeria. Usually that's what they do, right? Yes, now, assuming it's only for 5 million naira, Zenith Bank will hold the 5 million naira, Access will hold the 5 million naira, and every bank in between will hold the same 5 million naira, right? I assume that's the situation with you here. But it's only limited to the 5 million naira. The court did not place a hold on operations or on you operating your account entirely, right? It's only as to the balances that will satisfy the judgment debt. Are you informing the court now that the banks have have placed a restriction on you operating the accounts entirely?
Hello, that is only the mistake. That is under normal circumstances. That is the situation. That is what ought to apply. The restriction ought to be on the judgment debt. But my lord, if I can read out the Wema Bank's letter, my lord, that is attached to
it is before the court. I've seen the document. If Wema Bank has done that, they have just opened themselves up to liability because that is not what the court ordered. The court ordered it to hold.
We can't hear, my lord.
I can hear you very well. Can you hear me now? Mr. Kadiri, can you hear me now?
I don't know if we are the only one. We can't hear my lord.
I can hear my lord clearly. I can hear my lord clearly.
Yes, let's if you understand the court's position. The court only ordered the banks to hold the particular amount, not to place a restriction on the operations of the account.
Yes.
If the bank had gone ahead to do that, they must have done it in violation of the court's order.
Yes, my lord, I think that is even going to be a secondary issue, assuming that by the exigencies of the moment, your lordship is not able to deliver a ruling one way or the other on the application. We will then have been making an interim, an order for an interim request that your lordship clarify the order that was made, pending whether your lordship, pending when your lordship decides whether to discharge it or not to discharge it.
I believe
I think we should focus
the justice of the matter.
Yes, sir.
Is looking at the amount. The point I was trying to make to your colleague, right, is that looking at the matter, the court made an order for the banks to hold $178,000.
Yes, sir.
Right, and 420,000 naira. Now, it is possible that you have this money in Access Bank. Access Bank would hold 178,000 USD that they've got, that you have in domicile with them, in an account domicile with them, right? Now, GT Bank will do the same thing. Fidelity Bank will do the same thing. Wema Bank will do the same thing. And Zenith Bank will do the same thing, right? Now, judgment creditors usually do this because they do not know where you have accounts and where you have sufficient funds to satisfy the judgment debt. However, if you are able to confirm to the court now that there are sufficient funds for the judgment debt in Bank A, B, and C, right? And let the court lift restrictions in all other placed on all other accounts operated with other banks, that is fine. Because all the court wants to hold in the interim is the judgment debt, even if it is one particular bank. Do you understand, Mr. Akadiri?
Yes, my lord, we do understand. We appreciate that point, my lord. However, the difficulty we have here, my lord, based on what I was trying to explain, is that it appears that the banks misunderstood the purport of the order that was made by my lord. For instance, what Wema Bank just did, my lord, was to freeze access to all the accounts pending
Let me read the order
suit.
nice out to you, Mr. Kaduri, right?
Yes, my lord, we have seen it.
I hereby order to set aside the sums in their custody, right, to apply same to the satisfaction, right, of the judgment debt. Set aside these sums in their custody, THESE. And before then, the court had indicated $178,578.75 and 420,000 naira. So they were ordered to set aside these sums in their custody to apply same to the satisfaction of the judgment debt. That is all, no more, no less.
My lord, we totally agree with my lord. In fact, we did not only agree with my lord, we wrote a letter to the banks explaining this position to my lord, to the banks, explaining this position, trying to clarify the order. But my lord, the honest truth is, the banks, they have their own modus operandi. And we don't have...
Mr. Kaduri, you obviously need time to react to the counter affidavit. Is that correct?
Well, my lord, I wouldn't mind, my lord, we can proceed with this application if my lord will indulge us.
Understand, because I do not even have it. It was filed today. We can reconvene on Friday, but in the meanwhile, you could agree with Judgment Creditor Council as to where the well, that's even presupposing that the court may not even grant. But bottom line is the court does not need to. The other nice side could be lifted, right, as made against certain banks. If other banks have got sufficient funds to satisfy the judgment debt. Do you understand?
Yes, ma'am.
Before we even proceed to a ruling here.
My Lord, may I just quickly highlight a point, sir? My Lord,
Okay.
and if your Lordship will just indulge me, I'm in another office. Mr. Bolu Agbaje is in another office, but I will just seek your Lordship's indulgence.
That's fine.
Permission. My Lord, I think the matter, with deference to your Lordship, sir, the matter is even very simple. And regardless of the counter affidavit or further affidavits either party files, it will not change the character and the records of the court.
That is true.
It's apparent that the basis upon which the decree NISA was granted was on the erroneous presentation that there was one, perhaps no motion for stay pending, or two, that there was no, the judgment debtor had abandoned the appellate process.
You know, I cannot go into this now because it is the substance of the application.
Yes, so that's what I'm saying, sir. My Lord, my view, with all due respect, sir, is that on the face of your Lordship's records, it is apparent that and my learned friend has admitted from the bar that the counsel who appeared on that day was not counsel to the judgment debtor, but rather counsel to the judgment creditor. Now, a counsel to the judgment creditor purported to withdraw an application that was not filed by it. On the basis alone, ex-debitor justiciar, your Lordship is entitled to make a summary discharge of the decree NISA without even much ado, relying on your Lordship's records. Because he has admitted. Yes, sir. I'm sorry, sir.
This is what we'll do.
Yes, sir.
I don't know my course list for Friday. I would want, once they send the soft copy of the counter affidavit, right, I will have a look. We'll reconvene on Friday, maybe at 1 o'clock. And if you do not get a decision on Friday, you will get a decision latest Monday morning.
We are grateful, sir.
Is that fine?
We are much obliged. We are grateful, sir.
So that let the court have a look at whatever averments are in the counter affidavit.
We are grateful, sir.
If it is possible for the court to deliver a ruling on Friday, the court will proceed to do that.
Yes, sir.
Once parties adopt the processes,
yes,
right?
Yes,
if it's not possible, Monday, I usually say at 9. I don't sit beyond 9 o'clock, so we may be 12 o'clock on Monday. But I'm hoping I should be able to deliver a ruling on Friday.
We're grateful, sir.
Right?
We're grateful,
so that if I deliver it on Friday, whichever way it happens, by Monday you would have a copy of the decision.
Yes, sir.
Right?
As the company, we are very good for the indulgence. We do not bring our application to embarrass the judgment debtor. So anything that will meet the justice of the case, we are most grateful to the court.
Yes, I do understand the position of the judgment debtor. At the same time, there's a balance that the court needs to maintain a balance.
As the court
there's your interest, the judgment debtor's interest, as well as the court would need to be satisfied that he has done justice, right? So we'll convene Friday at 12, or at 1 o'clock. Let me be safer. 12 o'clock. 12 o'clock should be fine.
We are very grateful, my Lord.
So the court has not seen the counter.
Madam, we are grateful to the.
Hold on. So as the court has not seen the counter affidavit, the matter shall be adjourned for hearing of the pending application for Friday, 11/11/22 at 1 p.m. via the virtual platform.
As the court pleases.
Yeah, the court will, the registrar would furnish parties with the Zoom ID and password, just like for today. So thank you very much, gentlemen. We shall see again on Friday at 1.
We are grateful to the court.
God willing.
God willing. God willing. All right. Thank you. Have a good day, gentlemen.
Thank you.